Hello, I'm Lorena McElwain.
And I'm Sarah Somerville. We're co-founders of Smart Feds Law Group.
And today we're going to be talking about separations. That is, when a federal employee leaves the federal government. And you may not realize this, but when you leave the federal government, OPM categorizes that separation as a very specific type. Today, we are going to be covering two types of voluntary separations and three types of involuntary separations. Let's go ahead and get started with the voluntary separations. Sarah, what are the two probably most common types of voluntary separations?
Well, the most common types are resignations and retirement. The resignation is when the employee chooses to leave their job. And the retirement is when the employee applies for retirement benefits and receive them from the agency.
Okay, so these are totally initiated by the employee, and the employee decides when they're leaving and how they're leaving in those circumstances.
That's exactly right.
So one thing I'd like for our viewers and listeners to know is when you leave the government, you will receive a form called the Standard Form or SF50, Notice of Personnel Actions. And there's two boxes that are important in the context of separations. One is box 5A, which is your nature of action, and that will specify the type of separation, right? So if you resigned, you want to make sure that that box says resignation. And then box 24 is the tenure box. We all have a tenure in the federal government, and that tenure box, box number 24, will have a 0, 1, 2, or 3. If your tenure is 1, then that means you are under career tenure and you have non-competitive reinstatement rights if you decide you want to come back into government. And basically what that means is the government doesn't technically even have to post a job. If you are qualified for it, they can hire you back at the same grade level or lower than what you held in the past because you have fulfilled your competition and tenure requirements. If you have any other number, anything other than a 1, then more than likely you will have to recompete if you decide you want to come back into government in the future. So important implications to know about voluntary separations. But let's move on to involuntary separations. And today we're going to be talking about three. The first one is removal terminations. What do we need to know about those, Sarah?
Well, a removal termination is a firing for cause due to poor performance or misconduct. A removal is a specific type of involuntary separation. It's initiated by the agency rather than the employee's own choice. And it's an adverse action against the employee. It's a typically it occurs with issues related to performance or misconduct or some other type of issue. There is a removal process, is what I'm trying to get to here. And that removal process must be fair and it must provide due process. The agency must follow all of the guidelines and the law to effectuate that removal. Now, if these detailed procedures are not followed, the removal will not be effective.
So does that mean that if I believe the agency didn't follow procedure, I can file a grievance?
Yes, if you're in the bargaining unit, you can file a grievance at your agency. If you're not in the bargaining unit, most agencies will have a grievance, an administrative grievance procedure that you can file under. You also have other recourses, but yes, if they remove you without following the legal procedures, you will have a right to file a complaint through the grievance procedure or maybe an EEO complaint. through your office, civil rights office, through your agency, civil rights office. You have a right to file a complaint there. And you have a right also to go to the Merit Systems Protection Board.
So, one point of clarification, if my position is covered by the bargaining unit, but I don't pay dues to the union, am I still entitled to that process, or do I have to be a union paying, dues paying member to take advantage of that process?
That's an excellent question. No, you do not have to be a dues paying member as long as you are classified on that SF-50 as in the bargaining unit. You are eligible, you can take advantage of the collective bargaining agreement. That collective bargaining agreement was negotiated by the union on behalf of all bargaining unit employees.
One other follow-up question. Sometimes when the government is closed for whatever reason, inclement weather, there's a shutdown, sometimes the government is closed for whatever reason. Does that mean that I have more time to submit my grievances? What happens then? Should I wait for the government to reopen before I initiate that grievance?
Well, you should file the grievance in accordance with the procedure. If the timelines are strictly adhered to when it gets before a third party. So all complaints, all grievances, they should be filed and on time, timely.
So that means, for example, if the procedure is I have to file within 30 days, right? Then I have to be on record as having filed within 30 days, maybe either by electronic means, or maybe I send my grievance through certified mail. And I know on the other end, if the government is closed, they're not going to see it until the government opens, but I need to be on record as having submitted it timely.
That's right. Some agencies have a fax number on their website that you can fax the grievance, a complaint to. They will have an address, like you said, send it by certified mail. But yes, it must be filed on time because if it's not filed on time, you won't pass the first part of the complaint, and that is that it must be filed timely in order for the deciders to get to the merit of the case. You have to pass the timeline test first.
Great. Okay. Well, I think that's a lot of great information about removals and terminations. What's another type of involuntary separation that we should know about?
The reduction in force is another type, the RIF. Now, with the RIF, it's usually due to three things: a lack of work, a reorganization, or a lack of funds. So that's the three reasons. Those are three legitimate reasons for a RIF. And to challenge a RIF, you must file an appeal with the Merit Systems Protection Board. And if you're a union member, here again, or in the bargaining unit, you can follow the grievance procedure. And at some agencies, their collective bargaining agreement will allow you to file a grievance instead of MSPB. But if you want to challenge it before a third party, you must go to the Merit Systems Protection Board. And or you can also file a RIF through the EEOC, the Equal Employment Opportunity Commission, if you want to allege discrimination. So you have that as an option as well.
So if I was ripped and I want to file a complaint with the EEOC, or I want to file a grievance with the Merit Systems Protection Board, do I need to have an attorney to do that, or can I do that on my own?
You do not have to have an attorney. You can do that on your own. You don't have to have an attorney. If you have somebody that you know that's well versed in these types of complaints, They may help you out, go along with you, help you write up your complaint, but you don't have to have an attorney. These are administrative laws held before federal agencies. The MSPB and the EEOC are federal agencies. So you don't have to have it. It's not a court of law yet. You have to have an attorney to appeal to U.S. District Court, but not, well, I won't say you have to have one for U.S. District Court, but it would help when you get to the court system to have an attorney. But to file a complaint with the EEOC or the MSPB, no, you do not need an attorney.
And you mentioned, if I know someone, I can have them represent me, but I can also represent myself in these proceedings. Is that correct?
That's correct. You can represent yourself. Absolutely.
That's good to know. All right. Well, I think the third one that we haven't talked about is abolishment of position. That is a third category that we have. So, what do we need to know about that category?
Well, the abolishment of position, the employee's position has been eliminated. So if your position is abolished, your primary recourse is before the Merit Systems Protection Board. Or if you're in the bargaining unit, here again, the grievance procedure. So check your collective bargaining agreement first. Now, to build a strong case, though, you must prove that your agency failed to follow proper legal procedures and that the decision to abolish the position was based on unlawful reasons. So that's how you build a strong case.
All right. So, if somebody has been recently faced with an involuntary separations, how can Smart Feds Law Group help them?
Well, we offer services that will provide you legal, policy, and strategic guidance. We offer services to employees, to managers, to union officials. We can help you with your grievances. We can help you with your settlement negotiations. We can help you with collective bargaining when it's time to prepare for collective bargaining. We can help you with that as well. And all third-party litigations, we are available to assist and help you. Visit our website at www.smartfeds.net. Schedule a consultation or sign up with us for our monthly webinars. You can ask any question during our webinar, and you can stay current on the current laws. So if you found this video helpful, we ask you to share with others and to subscribe to our YouTube channel.
Yes, like this video and remember, stay smart, stay strong.